Everyone, myself Tanuja Raj, Assistant Professor of Commerce, Mannar Thirumalai Nayakar College. So today in Human Resource Management, we are going to discuss about the topic settlement of labor relationship. So labor relationship is nothing but this is a concept where every organization face some industrial disputes among the organization or between their employees. So how they are going to solve that issues. So that is what we are going to learn on today's concept. So there are three ways of settlement of industrial dispute. First one, conciliation. Second one is arbitration, and third one is adjudication. So in conciliation, there are two concepts. One is conciliation officer, and another one is board of conciliation. In arbitration, there are two types of arbitration. One is voluntary, another one is compulsory. And adjudication, there are three concepts. One is labor courts, and next one is industrial tribunal, national tribunal. So let us discuss about these three concepts. So first one is conciliation. So conciliation is nothing but it is a process where a third party comes to solve the dispute between the employer and employees, and there the conciliator cannot force a decision, and he has can only pursue parties to reach agreement. In simple words, conciliation is a officer who is being appointed under the Industrial Dispute Act 1947. So here the conciliation officer cannot force both the parties or any one of the parties, whether it is employer and employee, to agree on one particular um, choice or any one particular decision the conciliation officer is given, but only he can pursue them, he can convince them, both the parties, to agree or to come into an agreement to solve the dispute, but he cannot force any one of the party or both the party to uh, approve the approve the solution given by him. So here the conciliation officer is being appointed under Industrial Act 1947, and here he has to investigate what is the disputes being on among the employer and employee, and he have to conduct meetings and have to submit the reports collected by him to the government. So while the conciliation process is being on, the strike or lockout is being prohibited, whether the employer and employees is conducting a strike. Whenever the conciliation officer is being appointed, the strike is to be stopped, halt. And next, board of conciliation. This board of conciliation is formed by the government to settle the dispute between the employer and employees, and it also consists of two members. First one, the chairperson, and two or more members. So chairperson is an independent person who is appointed as chairperson of this conciliation board. He is also been appointed by the government, and apart from the chairperson, two or more persons is being appointed. They both the members will be representing the employer and employees. So the main work of this board is to investigate the problem, to conduct discussions and submit a report. So like the officer is also on the board, also cannot impose settlement. They can give suggestions to the organization and the employer and employee, but they cannot impose any suggestions. They cannot impose any rule or agreement on any one parties. And the next concept is attribution. So attribution is also similar to this conciliation, where a third party is coming to solve the dispute between the organization from the both the parties. So an arbitrator's decision is called as an award, is binding for the both parties, and it is also, the attribution is also considered as a quasi judicial process, which is similar to the court's decision. That in this attribution, it is similar to the court's decision, where both the parties is being given time to be heard of the matters, and to the both parties are given time to put forth their thoughts, opinions related to the issues, and from that what is right and good for the organization is being considered. So there are two types of attribution. One is voluntary attribution and another one is compulsory attribution. Voluntary attribution is nothing but where both the employer and employees agreed to refer the disputes to an attributor, And in compulsory attribution, the government directs party to submit the disputes to an attributor when settlement cannot be reached voluntarily. So when the settlements cannot be reached voluntarily by both the employer and employee, government will come inside and they will provide some suggestions on it. And the third one is adjudication. So adjudication is nothing but the legal and final method of dispute settlement. It involves the legal authority who is being appointed by the government. So that legal authority works to hear both from the both the parties, employer and employee, what are the problems being issued. Well, he has to conduct a discussion with both the parties, and from there he has to draw some decision. So it is used when conciliation and attribution fails. So this adjudication is being implemented only when the conciliation and attribution step is being failed. From that both the steps, both settlement ways, there is no proper settlement given, then only this adjudication is being evolved. So in this adjudication, there are three tier system of adjudication. First one is labor courts, the second one is industrial tribunal, and third one is national tribunal. So in labor courts deals with the dismissal, strikes, lockouts, unfair labor practices relating to the employees. So this labor courts deal with these things like dismissal, strikes, lockouts, and unfair labor practices from the organization towards their employees. Whereas in industrial tribunal, this industrial tribunal deals with the problems related to wages, hours of works, leaves, bonus related problems, provident fund related problems, and gratuity issues. So these things are dealt with the industrial tribunal. And at last, in national tribunal, this national tribunal is formed by the central government for the disputes of national importance, or when the industries is more than one state are involved. This national tribunal is being headed by the judge of high court. So these three are the methods for settlement of disputes. First one, conciliation, attribution, and adjudication. Thank you.